It's the water mic.
Thank you.
You're the chair, aren't you?
Good morning.
Vice chairs. Yeah, we're all vice chairs.
Good morning, Connétables. Thank you for coming in. In a moment, I'll just introduce ourselves as a panel. We're here to talk about the alcohol licensing proposition that the Minister for Economic Development is bringing forward, as well as a number of amendments that have been tabled, including one by your Comité. So I'm Deputy Montfort-Tadier. I chair the Economic and International Affairs Scrutiny panel.
Deputy Karen Wilson, Vice Chair.
Deputy Max Andrews.
Constable David Johnson, cooperative for the purpose of this review.
Thank you.
Mike Jackson, Chair of the Comité de Connétables.
Simon Crowcroft, Constable St Helier.
Kevin Lewis, Constable St Saviour.
Thank you. We appreciate having you in. As you're aware, this has already been debated in the first reading, and it was passed in the first reading, and then it just wasn't moved in the second reading. I think it's fair to say that during the debate there was a lack of consensus about what the article should be, and so the Minister effectively just held back on it, and I think did presumably some consultation behind the scenes, and has subsequently lodged his own amendment. So the essence of that amendment is that the creation of the alcohol and licensing gambling regulator is no longer going to take place, and this will effectively be done in-house by government through the regulatory directorate. So we'll be asking you about that, but can I ask, I suppose the first question really is about the amendment that's been lodged by the Comité. Can I ask you if will you likely be moving that?
Well, at this stage, clearly subsequent to our lodging that amendment, there have been two other amendments. And I think it's fair to say, well, I suppose it may depend on the success of those amendments, but the chances are we will probably withdraw that because it probably isn't achievable to get to the point which we were hoping for, particularly in line of the fact that we're getting towards the end of the state's term, and it probably isn't the time to debate it thoroughly, albeit we're generally supportive of the concept of reducing the number of categories, and that's really the principal point. The administration side can come later, and we have presently a consensus within the Comité supporting Sir Philip Parishes' proposal, but not all. So this will all come out in debate. So I don't anticipate we'll submit a comment to the debate, but we will each speak on our own merits.
So remind us, so your amendment essentially, tell us what it does and maybe what the motive for it, or the motives for it were.
It was stimulated by the Minister's initial proposal, which suggested using the Gambling Commission as an administration body to deal with that. We felt that within the parishes, and particularly St Helier, that we had the capability of dealing with it quite easily, and saw the Gambling Commission just as another layer of unnecessary bureaucracy. And that was the motive behind the amendment. I don't know if Simon's got any further comment on that.
Well, yeah, just to add that I supported, and I've always supported the idea of licensing being dealt with by the parishes, because we already do a lot of the donkey work anyway, and we know the people, both the clients who want the licenses and the people who live in the neighbourhood who sometimes suffer from the consequence of the licenses being granted. So I've always felt that the parishes should be in a position to have a licensing committee. And in respect to St Helier, I mean, it's well known that I've supported the creation of a council for St Helier, and one of the functions of the council will be to deal with the licensing as a licensing committee of that council. But the fact is, we're not there yet. We don't have that set up. And when we put through our amendment, it was quite clear from some of the feedback we had, particularly Sir Philip Parishes, who said that he felt that there would be conflicts involved in the parishes being the decision makers in licensing, because we currently have a parish assembly which might put a decision forward that the constable then found himself or herself wanting to vote against. That clearly wasn't going to work. So my view is that, speaking personally, that Sir Philip Parishes' amendment, leaving the final decision in the hands of the licensing bench, is probably the best place to leave it at the moment, because if we give it to a civil servant, is that any better than the Gambling Commission? It's still effectively a bureaucrat making a decision which is going to affect people's lives, which I don't really think is appropriate.
Was there any consultation with the Comité before the Minister lodged this amendment, his own amendment?
There was, going back probably a year, 18 months,
About the regulatory directorate I'm talking about.
He
so-
came to the meeting.
yes, he'd been to various meetings, and we had a presentation, I think you attended online last week, with regard to the latest proposals. So I can't say that collectively we've discussed that, but
I suppose what I'm trying to get at is that we're trying to understand, and we will obviously interview the Minister later on, but I would have thought that the reason for his amendment was to try and get more people on board who couldn't support the original proposal, and so you would have thought the Comité had the obvious first port of call to get them at least partly on board, and then possibly the industry as well. But did that not happen?
not in effect. I mean, apart from the meeting we had last week, so we haven't had a presentation from the Minister. To my knowledge, am I
I
right?
think
in
states
saying-
members have been invited to one.
Yes, that's the one we had last week.
Yeah, okay.
So there are mixed views from within the Comité, I have to say, but generally, I think the majority consensus is towards Sir Philip Parishes' proposal. And I can outline the reasons for that, in that we feel, and I suppose I have a conflict in that I have an involvement with the environmental department, obviously the regulation department, and I'm full of admiration for the officers there who play play a part in the operation of the process already. But I question whether they are the right body to make the final decision. And I feel by delegating that function to a bureaucrat or a fonctionnaire, as I probably would call it, is probably not correct, and it takes the gravitas out of the whole process, and that's what the licensing bench retains, and that's the enthusiasm for keeping with them.
How do you respond to the Minister's point that having a centralised system, whether it's through the regulatory director or what it might have been previously with the Gambling Commission, that the benefit from his point of view, he's saying that it ensures a level playing field, that local considerations will still be taken into account at parish assemblies where licensing goes to, but ultimately the granting will be done by a central body, which isn't perhaps susceptible to what one or he might call NIMBYism. Is that a reasonable?
I don't think that the licensing bench is susceptible to NIMBYism. As I said in my speech when we debated the principle, there have been occasions where the parish assembly has been influenced. It's been stacked, to use the phrase, and something has been voted down, which is actually quite reasonable. And if one's being fair-minded, probably should have been awarded a license. And the licensing bench has overruled the parish assembly and said that.
So that, I think that's correct. So what you're saying is we're talking about Sir Philip Balash's, Deputy Balash's amendment. You'd support that, but if it was your amendment and it stood, of course, that would put the power within the parishes. And so I suppose that's the question. Is that so? That's no longer your first preference, just to confirm.
No, I think the reality is we will be withdrawing, but I need to get the consensus from other Connétables before I do that. So that would be my suggestion. And which direction others go may be as a result of whatever you come up with, and will be influenced by that, I'm sure. But personally speaking, my inclination is to support the Parishes amendment to the ministers.
Do we know what consensus there is amongst the Comité?
Can't say. I can only speak.
I would
Three
agree.
votes.
Absolutely, indeed. Yeah.
Okay. Thank you for that. I think at the moment, let's turn our attention maybe to the regulation directorate, if we may. So, Deputy Andrews, are you happy to lead on that part?
Yes. Obviously, the panel is aware that the Minister has made a few changes, and obviously now he's brought forward the regulation directorate. And I just want to have your views on whether you feel that is an appropriate decision that the Minister has made.
I feel that whilst the regulation directorates are good at dealing with the process at the moment, which they do. They have systems to deal with that. There are some elements missing, and one is over the premise ownership, and that raised its head during the Lido debate. We've got another one coming up at Simple Large shortly. And so there is some work to be done. But when it comes to the ultimate decision at the moment, if the parish assembly recommends a licence for approval to the licensing bench, the public have the opportunity to attend that licensing bench and make any comment. If it's taken purely within regulation, the regulation directorate, that it seems to me will disappear. I think the other point I'd like to make is in terms of enforcement. At present, each parish has its own honorary police, and they in fact form part of the process of enforcement. With due respect to the planning department, but it's all the same thing, they're not actually very good at enforcement. I'm not criticising any staff members at all, but we see regularly complaints from the public about things not being enforced. So I do question really whether there is the ability to carry out the enforcement that we would feel may be necessary.
Okay, and in terms of looking at the resource within the regulation directorate, do you think there is enough staff to at least cover the basics, or do you think there will be a need for additional personnel in the future?
Well, my feeling is that they deal with the situation as it is at the moment, but if it expands to more to enforcement, or should we say the more difficult applications where it simply takes more time to process for whatever reason, I think it will be more challenging. All departments are struggling for resource, and the department will probably need more resource to do that.
Yeah. And in terms of the Connétables interaction with the regulation directorate, I mean, have you been liaising with them in the past, and how well do you also know the team who work there as well?
Well, very well. We liaise with them. I think it would be useful if Alison were to speak at this point as parish secretary, to tell you she's the key person, should we say, that does that. You might like to expand, Alison, on what you do.
Yeah, I think we liaise well with the regulatory people, but also with the court.
Yeah.
But it is for businesses, it is a very long-winded process to get your licence. We tend to sit in the middle, and a lot of people come to us for information before they would even go to economic development or whatever. They come to the parish because that's the people they know. So I don't know. I feel that even the regulatory stuff could be done with the parish, but the decision be made by the court. I'm not sure.
Yeah.
The three processes makes it.
Can I ask something that which exercised our mind previously, and I think I might have raised it with Deputy Constable Jackson previously, is that if a shop or a chain of pubs, restaurants has a presence in multiple parishes, and they need to, or even if it's a new entity coming in, and they need to go to 5-6 parish assemblies to get a licence, that might be seen as against government's mission to reduce red tape, and there's also a cost and time involved. Is there currently a way around that?
Yeah, we did, in fact, when there was a change with the was it Morrison's ownership, and effectively there was one decision maker amongst the Comité that took that forward, and it was quite seamless. So it wasn't a question of multiple.
How does that work? Because are you effectively saying to other parishioners of different parishes that they don't get to have a say on the licensing?
Well, it wasn't quite. It was the change of licensee. The licensing of the particular premise was the same. It was a change of name above the door, in effect.
And Alison, did you want to?
What's being put forward is still going to go to each individual parish anyway, so I don't think that will come away from it. I think that the applications will still go to a parish assembly, and it would have to go to whichever parish the person. So that's not really going to alter anyway.
Yeah. Is there a need for a parish assembly if essentially things are coming to the elected constable? So the constable's been chosen by the parish, by the parishioners, to do a certain job, and should we not be putting it to the discretion of a constable?
My view is that it should always go to a parish assembly, because there are, with most applications, generally there are a variety of views, and you have to take them on board. And then, of course, there is a vote at the end of that assembly. Those votes are noted, and that is in turn recorded, and the report sent to the licensing bench. Anybody who speaks at that parish assembly is entitled to speak at the licensing bench. So if there are strong views, they have two opportunities really to say their piece. So I think it's a very democratic process, and personally I would support it.
And the bench also does seek the views of the Connétables, so the Connétables' views are taken into account at that stage. Yeah. I remember when I started my job, there was a feeling that St Helier had too many first category licences. And these were being routinely turned down by the parish assembly when anybody wanted to start a new bar. It was being turned down because the parish didn't like the idea of any more first categories. And I put forward the argument to my first bench that it wasn't the quantity of first category licences that was important, but the quality of them, the way they were run. And that meant that an early decision by the parish assembly to refuse a first category was overruled by the bench, who approved it. And that was, I think, my influence probably helped that.
And what's so special about alcohol licensing that it needs a parish assembly? I mean, parishes don't currently approve. You don't convene a parish assembly routinely for planning applications, or if someone wants to open a cafe.
Planning comes to the roads committee, so there is a route there that the roads committee, in our case, at Helier's case, that's held in public, so the public can influence, and of course they can write in themselves.
But they consider
anyway.
them, don't they? It's not automatic that a parish is.
Yeah.
I think it's important that parishioners do have an opportunity to comment. I mean, you see a variety of applications. Some are quite innocuous, but others where there may be a restaurant licence popping up in a residential area
Or a nightclub.
that'll cause some concern.
Could it not be done as a paper-based exercise, so that if anyone who's got an issue writes to the parish or writes to the licence bench and says, look, we've got concerns with this, and you presume a constable would take it up on those behalf.
It is possible, but as you know, people don't always want to write, and sometimes the parish assembly where people can speak up is the effective way of dealing with it.
We don't have too many licences in St Saviour, but there is an expectation that we will have a parish assembly for any alcohol licences. And we've had a few objections to one or two. It's in the wrong area, and we've had to pull a few people up on certain things. But basically, the present system works well.
Can I just, before Karen comes in, just in terms of publicising the parish assembly, we did one a couple of years ago now, where there was previously a process by which you put an advertisement for the parish assembly Evening Post. It's not obligatory by law. The obligation is to put it in the Jersey Gazette, and on that particular occasion we did, and I was roundly criticised soon after by not putting it in the Evening Post by some people who wished to object. So we have to use all the tools we have available to us, parish websites and so on, to make sure the assemblies are publicised, so people do have the opportunity to make their comments.
Mm-hmm. Thank you. I was just going to ask the question, what seems to be a thorny issue in the debate, if I may, is where the responsibilities are for administration as well as enforcement, and that there is potentially some conflict around that. Can you just give us a view on that?
Yes, I can't think that the councils really have a conflict. That, although it's been mentioned, we are heads of our honorary police service, but we're not operational in that. So if there are any particular licensing issues on the ground, it'll be the chef de police that deals with it, and in conjunction with the States of Jersey Police. And it does happen, and and there is a suggestion that any licensed premises closure will be dealt with by the chef de police, which is the right way to deal with it. Sometimes they do have to be closed down, and the centennials have to attend.
Mm-hmm. So what you've just described is that over time there's been different ways of administering the licence permissions.
I think, truthfully, and it would be the same with the Regulation Directorate, it's down to encouragement and enforcement. It actually is the last string on the bow. I think we have to be cognizant that if you close a licensed premises down, for whatever reason, there could be a financial consequence. And whilst that shouldn't override the reason for closing it, it's something that has to be considered, as there may be subsequent claims if you get it wrong.
It was more about, Mike, the issue that you just alluded to there, which was the notification in the Gazette. And then we've actually got a parish administration system where people make an application. And now we've got a different kind of proposition here. So my question really is, what have the Comité considered when addressing this particular proposition, knowing that there have been different ways of actually administering the request for a licence over time? And have you got any particular view as to what was the stronger arrangement in those options?
Well, to be quite frank, and due to the shortness of times, we hadn't considered the Minister's latest proposition in depth in the Comité, so it's only been anecdotal discussions. I think it's because we're short of time, it's all being pushed a bit hard. To me, the easy win, and I'm thinking of the hospitality side of things, who are really keen for a reduced number of categories. The easier process probably is to go down Sir Philip Parishes' amendment at the moment, because that retains the existing licensing bench, which we're perfectly happy with, and even the licensing bench are perfectly happy. And I can confirm that by saying that in the December licensing bench assembly, where all the Connétables turn up and present our annual reports, the bailiff did suggest that whilst he didn't wish to be political in any way, he just indicated that the bench were perfectly happy to continue with the existing process. So the objections, if any, are not coming from that direction. It's the Minister's wish to turn the process away from the licensing bench for his own reasons.
Yeah, well, thanks for that. A few more general questions later, possibly, but I'm concerned that the Constables will tell you, are you leaving us at a certain time, or are you here for the...
At 5:30, if I may.
Okay, that's fine. I was aware of an earlier deadline, as it were, but I'll leave alone for the moment. So.
I mean, you feel free to...
Well, okay, that's wrong. I mean, it's a general point. I mean, the difficulty of the panel is, of course, we have 3 amendments in front of us, and we're probably trying to steer a certain way. Now, picking up on the Constable Hellier's point, you're basically in favour of leaving well alone for the moment. The 2 objections have been raised to that. One is, I think, that in Deputy Parishes' amendment, there's no reference there to a policy advisory group, and there is this question as to whether the licensing bench is in a position to exercise the power of the executive at the moment. That's one thing. And the other aspect is relating to appeals. If one doesn't like the licensing bench appeals, so you appeal to another version of it, presumably. I mean, taking the second point first, I mean, how often does an appeal, in your experience, Constable, happen from the bench?
To the Royal Court, as opposed to the licensing bench? I can't remember one in 25 years, so I think that's...
Is that because they think there's no point, or because...
I think the system of effectively two audiences, it's heard by the parish assembly, then by the bench, and there's normally a similarity in the views. It's not often that the bench would take a different view to the parish assembly. So the idea that this should be a point of an appeal is quite rare. And I suppose also we have quite a liberal system. I mean, the fact is that we do have a very healthy hospitality industry. Most licenses are approved. The only perhaps bones of contention are things around the conditions that the bench will impose on the licensee, which might be to do with the hours of opening, it might be to do with the number of security staff, but that tends to be where there might be a bit of a pushback from the person presenting to the bench. But normally, as I say, because they want their license, they're going to accept conditions, and they may come back to the inferior number in due course to see if they can get those conditions changed in some way. So the whole system, to my mind, seems to work pretty well.
I think online your advisor Ian Clarkson would like to speak. Is it all right to bring Ian in?
Of course.
And Ian, just introduce yourself for the record, if that's okay.
Chair, thank you. So my name is Ian Clarkson. I'm currently working as policy advisor to Parishes St Helier and the broader Comité. I just had 2 points regarding the earlier topics you were discussing. The first was around the consultation process, and the second is then the link in to the policy guidance. It was just to say that I fully understood and respected your point, Chair, about the methods of consulting stakeholders on applications. It's probably fair to say that I think I remember discussing this with the Comité. We were mindful that the current system of engaging with stakeholders has been the parish assembly. Historically, it's worked very well, which is not to say there aren't alternatives. As you rightly said, the planning process has an established procedure for people to write in and make observations on the planning applications. And in that particular context, the system, I think, largely works well for the broad range of stakeholders. The reason I'm now going to talk about policy guidance briefly is just because the alcohol licensing process that you might be moving to with the new law is a little different. You're moving from, or potentially moving from, 7 license categories that are effectively boxes that your applicants are dropping into, and multiple stakeholder groups effectively know what they're getting when they see an application in their particular parish. They've got a broad sense of whether or not the premises are pubs, restaurants, private clubs, hotels, entertainment venues, for example. In the new system, you're looking at an on-licence or an off-licence, and you're then having to do additional work to take additional steps to understand what it is that you're being consulted on as a neighbouring resident, States of Jersey Police, politician, parish, etc. So the process is a little bit different, and that then brings me to the policy guidance. It's going to be, I think, particularly important for whoever's taking the decision to understand that they're going to be effectively triaging applications with reference to, I think, primarily that policy guidance statement that you can't see yet, even in draft, because it hasn't been written. And whoever the determining authority is going to have additional work to do to themselves understand what they're being asked to take a decision on. Just as stakeholders are going to have to potentially do a little bit more work to understand what it is that they might want to express a view on. And that may have implications as to whether or not you consider that the parish assembly or an alternative method of public engagement is going to work. And just to finish, that I can say quite happily that if the parish administrations had been in a position in future to administer these applications, I could readily see and talk you through how I think that process would have worked, and I think it would work quite well. I think it will be interesting for your panel to consider how that public consultation process is going to work effectively in any of the other systems that you're looking at across the amendments. But I think you're possibly already doing it. But bear in mind the policy guidance that you can't see yet is going to be really key to how this process works and what the job of work is that the determining authority is going to have to do. I hope that's helpful. Thank you.
Thank you. I suppose the question I was also going to ask is regarding the appeals process. Is it really a good use of the Royal Court's time and the Jurat's time, even in the inferior number, to potentially be sitting as an appeals body? I mean, the Royal Court's the highest court in our land, and should it be opining on alcohol licences?
Well, given as time suggests there hasn't been one in the last 25 years, it's not going to be a regular occurrence, I think it's fair to
But
say.
I think as Constable Johnson said, there's a risk that might be a symptom of people not wanting to engage with the system because they think it's the same person effectively marking the homework. So why would you? I mean, it'd be interesting to know what the healthy number of appeals should be. And I suppose we can take this back to there's been some criticism from the industry leader. I mean, I'm not going to suggest that necessarily Marcus Calvani speaks for everyone in the hospitality industry, but he and his wife are the representatives of that body, and they've talked in quite stark terms about this being anti-business, creating more red tape, perpetuating red tape. Admittedly, I think those comments were initially in support of the Gambling Commission, but that they seem to be generally supportive of a more centralised system which is uniform. Do you have any comments about that?
We did have a meeting with Mr. Calvani and a member of the Chamber of Commerce, and it was quite a long meeting. At the end of it all, it was agreed, we all agreed that the categories need to be reduced. And my take of that meeting is they were quite ambivalent as to who administered it, because at that point we hadn't had the subsequent amendments and we were proposing our initial one. That said, as has been mentioned, I think the fair assumption is we will withdraw that until I get the input from my colleagues. I don't really want to officially say that. I think one of the points which isn't really covered in a lot of the amendments is the arrangement with managers. Now, you'll know that if a license is granted, there is a licensee. Very often in a bigger company, that licensee will be sat in an office in town somewhere, managing all the pubs and outlets throughout the island. They in turn will have a manager, and the parishes at present interview these managers, and I can tell you there's a significant turnover. And one of the reasons why I feel that the gravitas of the licensing bench should be retained is to make it clear to those involved that actually it's quite an important job. Some of the hospitality sector may wish there to be no controls at all over licensing, but we all know that some of the public aren't too good at managing alcohol, and you can go back hundreds of years, it's always been the case. So I think we need to manage it in a sensible way at a local level, which is really what the parishes are keen to do. Just keep a handle on what's going on. We know at ground level what's going on, and we don't see any reason to change that.
And there's a level of accountability that we have at the December sitting. All the constables present their books to the licensors, and we're asked by the bailiff how we've got on, how the honorary police have got on in inspecting premises. That's something they do in the course of the year. And there is that onus of responsibility on every Connétable to be able to say that licensing from the parish perspective, including the enforcement by the honorary police, has been conducted in an appropriate manner. I think that level of accountability would disappear if this matter was being dealt with internally by a department of the states.
I think it's fair to say that I'm sure it's the same in most parishes. I have a particular centenier who applies himself to checking all the licensing premises. In fact, a few years ago, I recall at that December meeting that one parish was heavily criticised for not doing the check. So we certainly and I'm sure all parishes now do make a point of doing that. And they do pick up points, encourage the managers who are on site at the time to correct their ways if they've gone wrong. And there have been occasions where in my parish, the premises has to be closed until such time as they put the house in order. So it is very much a last resort, but they have the Sheffield Police once again has the ability to deal with that.
Okay. We've only had one in recent memory. I won't mention the public house, but there was lots of disorder, lots of rowdiness, and they just would not listen to reason. And obviously I'm the constable, but non-operational. So I was informed of the incidents as it progressed. It was in association with the Attorney General. The licence was suspended for a week until things were put right. And they were promptly put right. And then the premises were allowed to reopen again. But I say the constables have been non-operational since 2012, I think. So I think the constables in Brad was the last constable to hold a warrant card. But that's completely non-operational. I was informed of what's happened. Thank you very much, Chef. and so they were reopened very, very quickly.
So is it fair to say that Deputy Balash's amendment will effectively put us back to where under the current system, but allow for the technical changes to come through, the reduction in licence categories and possibly some other smaller matters?
Yes.
Is that
In short, yes.
in short? Yeah. Okay. And do you envisage that would be then the end point, or do you think that's more of a pause for thought to enable maybe some consideration to be given to how the licensing operation may be further streamlined, or how more parish engagement may happen? I mean, one thing I would ask is the fact that it's not critical of the parish assembly system, but it does tend to attract small numbers, and if it's on a particular night of the week, first of all, you have to know about it, and secondly, you have to be free to come along. Is there an opportunity to maybe make it more dynamic to allow submissions and people to speak?
I mean, speaking from my position, because I'm retiring, I don't know whether the next Constable St Helier will be keen on developing the idea of a council, which one of the reasons for that was to get over the problem with parish assemblies. As you say, they're not really representative of the 18,500 people who could actually turn up on the night and make their views heard. So the idea of delegating some of these functions to a committee of a council seemed to be sensible. But I think the reason I was opposed to the minister's proposition was that by placing this either with gambling control or with a civil servant in his department, it would make it more difficult for the next Constable St Helier, if they wish to pursue the idea of a council. It would actually take away one of the most important things that we do and park it in a position where it would be harder to progress from.
I think
Sorry, Jack, can I just check, Simon? So what you're saying is that the permissions are as equally important as the enforcement responsibilities, and you don't see any particular issue in the parish fulfilling those two functions, and that what Deputy Balash's amendment does is it allows you to complete your responsibilities around the permissions as well as retain the enforcement plan.
Well, I think because his proposition effectively is the status quo in terms of the permissions, I think it means that can be returned to later on. A future parish or comité may decide to pursue that. I was just concerned, as I said, that the minister's proposal would make further work on this more difficult.
So the reason I asked that question is because if the minister's intention is to take the permissions element of this away from the current responsibilities within the parish, what is it that causes concern for you if the real issue that you're dealing with is the enforcement of any decision that is taken that affects parish life?
I'm not sure that the minister's proposal do still consult the parish.
Yes.
But I think, as Alison said earlier, we have a lot to do in terms of the initial advice we give, interviewing the managers, making sure that the right person is being put forward as a manager. There's a lot of work that the parishes are doing to make sure that the process works well. So it isn't simply a matter of the permission at the assembly, it's all that preparatory work and advice that we give.
Constable Jackson, you...
Going to your point, I mean, it is a question of evolution. We've seen the licensing process evolve going back to the 1771 code. So, and I think we'll continue to do so, but we have to consider the hospitality industry, who are the ones who've been asking for this reduction in categories, and we're all keen to do that. We have to adapt to modern society, which has changed, and I can say that given that probably some 50 years ago, I actually worked for one of the breweries delivering beer, so I've seen inside the cellars, but we've moved on from the, should we say, the drinking bolt holes that were the situation then to more catering establishments. And I can see the advantage of going back to the regulation, linking the food regulations to inspections. We already have the public health inspections when we have presentation of parish assembly, so that would seem logical that will be included too. So whilst regretting the fact that constables no longer have to taste every barrel of wine or can of cask of beer, we've moved on, and we will continue to do so, doubtless.
Yeah. Is it fair to say that, I mean, there were three options for the way licensing can be done? It's either leave it as it is currently with the judiciary, or as a slightly judicial process. We move it to a centralised government function, which would currently be done by the regulatory directorate, or it can be done by the parishes themselves. Now, what we've heard from yourself, Constable Crowcroft, is that your vision is that that could be a devolved power for the parishes, certainly for the parish of St Helier, and we know about the model of St Helier Council, but that's not something that you've got necessarily wide support from your other Comité colleagues
No,
for.
I think the Comité, when we actually discussed the proposal for a council at the same meeting where we had our initial meeting with economic development about the licensing, it was the next item or the item before, I can't remember. And I seem to remember there was unanimous support from the Comité that St Helier should move towards a council structure.
And is the idea that St Helier in the future may be the central point for all licensing applications initially, but still with input from other parishes?
Yeah, it'll be up to the constables of the day, but there's no reason why that service shouldn't be supplied by the parish.
So it's still effectively a one-stop. I mean, the minister's very clear that his model provides a one-stop shop. It's the regulatory directorate doing it all anyway, so why not just effectively let them make the...
Well, I think the point's been made that they're not doing it all at the moment. The parishes are doing a great deal.
Yeah.
And if all that was handed over to the directorate, A, I think the service might suffer, and B, the capacity of that part of the civil service to do that work would be stretched, and they would have to employ more people.
Okay. It is what we're seeing here, and I'm just trying to understand the politics of it. I think it's easy to resist and oppose a change that collectively you may have reservations about, but it doesn't mean that you all necessarily share the same vision for what it might look like. So is there that vision for putting it in, ultimately in the... Because I think the panel has legitimate concerns about the judiciary doing an executive role, whereas it may do it well, but it's probably not really what we should look like in the 21st century. So I don't know if you've got comments on that.
I appreciate that's a comment that has come back from the Minister. It hasn't been a problem to date, I think it's fair to say, and the licensing bench has built its Chinese walls, if you like, between itself and the judiciary. And I think retaining the gravitas of that body to manage licences and managers is really quite crucial. It's an important role. The manager of a premises really has quite a part to play in the area in which they're operating. And I think it would be a shame to lose that, truthfully.
Yep. So I go back on the same point, the clarification of any executive power the licensing bench might have. I mean, it's been alleged that they do have executive power and that there's the happy hour situation. In fact, we've gone back to it. It was their decision, and I understand it. It's a question for the minister rather than yourselves, but that's what militates against the leave it where it is. I mean, my point is, if there was a alcohol policy group, as described by two of the amendments, could not the licensing bench as is work with that? And would that be, do you see that as being
I'm sure they would be
a form of restriction on their activity?
Well, I think some guidance would be helpful to them. I don't think it would restrict their activity, but I think if they had some policy guidelines to work to, it would be extremely helpful for them.
Well, they could say, and I'm not sure I'm betraying confidence, but in a scrutiny review 10 years ago, they made that very point that they give us guidance, they were saying, so they are.
I can understand
that is a possibility. Okay, thank you.
There's a question here that I wanted to ask, and we may have gone slightly off piece, but I think we've been doing a broad brush, and you've largely answered most of the areas that we'd like to ask. The Minister's amendment does introduce an additional requirement for the Regulation Directorate at the moment, if they were to get it, so to speak, to publish a notice on gov.je inviting public representations alongside the parish advert that goes out. Do you have any views on that?
Just rather seem like another layer, which might bring comments, but truthfully, I'm not sure what it's going to gain. Maybe the idea of that is to cover off the inability of the public to speak at the licensing bench.
Yeah.
That's the only motive I can think of. But
I mean,
think
surely if it casts the net a bit wider, it's to be welcomed, is it?
There's no reason why the parishes shouldn't invite that kind of feedback as part of the work we already do. I mean, I frequently do get emails and letters from people about a licensing matter that's coming up. They say, I can't come to the meeting, but please can you say such and such at the meeting? So I think that could be formalised. It'd be quite useful to formalise it in a way that people felt they didn't actually have to turn up on the night to make their comments.
I can agree with that. In fact, I only had one this morning. We have an assembly tomorrow evening to consider 2 licensing applications, and I had exactly that, an email from a member of the public couldn't come. So,
And I suppose we've got to be mindful, we're a small island, there's also a possibility you could have an establishment which is, especially in St Saviour, could be very close to St Helier and St Clement, you know, if we just think about Ovdepar.
We're the second largest parish by numbers, but we don't have a huge amount of licences. But I would agree with your comment earlier that we would really love to increase the amount of people that come to parish assemblies. But people are very savvy and they know what's going on. I find if it's something that piques their interest, they are there. I mean, you could come to a parish meeting, maybe 23 people, but a major planning application for a new estate or similar, suddenly the whole parish hall is full, and all points in between. So we do have a mail out for people who can join the mailing list, and we do inform people of upcoming meetings. But I would say that people are generally pretty savvy as to what's going on.
Okay. And are there any mechanisms that you could propose for cutting either red tape or perceived red tape?
I'm all in favour of reducing the categories down to 3, the simplification. But I don't see any other problems that we have at present to change. That, you know, as has been said, we report at a licensing assembly and everything seems to tick over quite nicely. The only sort of complaints we get on a regular basis now are for licensed events, marriages that go on to 3 o'clock in the morning and sound disturbances. But we feed back to the bailiff's office on special permits on a regular basis.
Could I make one parting comment, which is that some licensees still feel it's necessary to employ legal advice to make these representations. And I always stress to them that you don't need to have a lawyer in the parish assembly or indeed at the bench. I think the bench probably, as we do, prefers to hear from the people concerned. So you can save money that way, even if you don't save red tape.
And they've obviously got audiences and a right to an audience, even if they're not a parishioner, just by virtue of having a presence in the parish. So,
On the other side of that, do you get any particular complaints from businesses about the process and the system that's in place at the moment?
Alison probably answer that better than I can.
you can come and join us. We should have invited you closer earlier, but
I think businesses do find it difficult having 3 different people that they have to go through. They do find that onerous, and I think anyone would. And I find it quite frustrating from a parish point of view that we tend to be, well, I feel we tend the first point of contact, but then I have to push them to the government to make their application. Then when their application's made, it comes back to me. We collect together all the reports. We put it to the parish assembly, then I push it to the court. So I do realise that they are pushed from pillar to post, but I honestly believe that I don't see any reason why the parish couldn't do the application process. We also do the shows public, so it's still going to be bitty no matter what economic development do, because the parishes then, you have to licence your outside areas, and that is something that the parishes have the responsibility for shows public permits. So I see it, if it came to the parish, the applications could come, the parish assembly could be held. We could also do the shows public at the same time, so that when the application gets to whoever it's going to be heard by, it is a full application. And I think the parishes would have no problem doing that. I know that some of the smaller parishes maybe don't do it so often, and I think from the administration point of view, I don't see why St Helier couldn't do that for all the parishes. Okay. Obviously, when it comes to parish assembly, it may have to go out to their own assembly for their views, but the actual application thing, it could be done in the parish. St Helier.
Is that something that would be supported by the Comité?
Well, I can't say. The numbers vary. I mean, I don't know how many licences you've got.
We've got 2/3 of the island.
Yeah, so I know we've got 62 in St Billard's, and but some parishes have 1 or 2 or 3. So there is an enormous variance, and I would have thought that those parishes with very few could work through St Helier quite easily. We probably got too many to be fair to do that, but I think that's something we could discuss at committee level.
I think Ian.
Thank you, Chair. Just a couple of points to go back a couple of minutes. In fact, the first is to say that you were referring to scope for streamlining, reducing red tape. I think one of the ways in which there is an opportunity here is a subject that, Chair, I know you're quite fond of, which is public entertainment regulation and the scope for combining whatever way forward is picked here. With or doing it in such a way that you could perhaps take care of some of the event regulation that still is going to need to happen, and which currently happens by law via the bailiff's entertainment panel, which is not to say that you wouldn't want potentially to consider having that body continue with your larger scale events. I think certainly from an administrative perspective, I've seen that panel work exceptionally well at regulating large-scale events with potential multi-parish impact. But there's potentially a range of smaller scale events which are quite often linked in terms of what happens. They're linked with the liquor licence application process and the premises or body that applies for the licence. There is potential here to reduce red tape by looking at the future mechanism you're contemplating here to take care of both alcohol licence and the sort of small scale event regulation that might need to happen alongside it. The second thing to say is just that technically, in terms of the conversation that you were having with respect to the role of politicians and the judiciary with respect to liquor licensing, it's perhaps worth flagging that under the existing 1974 law, that the Constable's original amendment flagged the fact that there is an opportunity under the existing law to set clearer parameters and take more control, if you like, of the policy that the judiciary, the licensing assembly, would apply. And you can do that by having an alcohol policy guidance statement of sorts, perhaps developed as a schedule to the existing 1974 law, and simply amend the existing Article 6.9 of the 1974 law, so that in addition to the licensing assembly taking into account the interest of the public in general, the nature of the business to be conducted, and the suitability of those premises for the business that's planned, and also taking into account the views of the parish assembly, you can simply insert and the licensing assembly shall take account of a license policy statement appended to the law as a schedule that the States Assembly can determine the content of. So there's nothing stopping the States Assembly from taking more control of licensing policy tomorrow under the existing law. And I think it's just worth flagging that, because I'm aware there's a line in the minister's comment, I think it's to the third amendment, that refers to the licensing assembly potentially having nudged the margins in terms of taking control of the liquor licensing process. I think there is an alternative view that it's been perfectly open to the assembly for some time to add in a more policy guidance in the 1974 law. It's just for whatever reason it hasn't happened, and the licensing assembly may take the view that they've just done the best that they could to fill in some gaps.
Yeah.
So you can have more control of that licensing policy tomorrow if you want. You don't need a new law to get it.
Thank you.
Can still have the licensing assembly taking your decisions. Thank you.
Thank you. I suppose the question there is that you're only then really asking the licensing bench to enforce to the policy, and you're still at their mercy. I mean, I suppose this then raises the question about which should come first. There's a chicken and egg here, and we don't know what the policy is going to be that is going to be enforced. So of course, I mean, do you have any thoughts on that?
Broadly, I think the policy will adapt to today's requirements. I mean, there has to be some parameters around alcohol sales. We've seen the situation whereby off licenses don't pay very much in terms of their licenses, and I think that needs to be brought up to line with on-license costs. We've seen a change in demand, and that goes back to the reduction of categories, in that we've got various establishments wanting to have a first category, wanting to have a restaurant license, and they can sometimes have as a hotel, a residential as well, and it just seems a little bit of a mishmash. So I think that's got to be the way forward, and a policy statement would outline that. In terms of, as Alison said, in terms of the entertainment side, that could potentially be incorporated in that policy statement too, because it very often is linked to the application.
Do you think that there might be a position here, if it's debated this week, which is we're anticipating it will be, that rather than necessarily adopting Deputy Balash's amendment, for example, the Assembly might just ask the Minister, or the Committee might ask the Minister not to move certain articles, so effectively only move the articles which deal with the matters been spoken about, rather than the fundamental ones which shift will create the new powers to the Directorate.
It's possible, but it's all a question of time, and we're pretty close to the buffers. And from a Comité point of view, we have monthly meetings trying to get. And clearly we need a consensus from everyone to take anything forward, and I'm certainly happy to do that, but time is not on our side.
Yeah.
Can I just ask, Alison, can I just ask you, in terms of how you've just described the role of the parish in bringing together all of those elements of licensing, different various reasons for doing so, what do you think that these proposals present for you in the parish in terms of additional workload or additional resources? Do you see the expansion of administration in the parish, or is it particularly going to be absorbed?
Yeah, I mean, I do think we would require additional resources to do it, but only minimal, because a lot of my work is doing the licensing along with lots of other things that take place. Obviously, when you're talking about new applications, you don't get hundreds of applications. You know, when it comes to renewal,
Sure,
or you're renewing applications, that's when there's quite a lot of applications. But the number that come through, I think we've got in a parish assembly coming up, and there might be 7 this quarter or 8. So it's not huge amounts that you've got to do. I do think that obviously at the moment, everything the parish does, they don't receive any pay for, or any of the fees that come in. So, yeah, I think there would be an element of, we would, obviously, if we did the administration process, would also appreciate to have the fee that goes with that. And therefore, if we did require part-time post or even a full-time post, that could come out of those fees, which is something the parishes is not getting at the moment.
but the other thing that you talk about is that if you're dealing with different types of licenses, in terms of the interrelatedness of some of those things, that's going to make the system more efficient.
Yeah, I mean, I just think that the process could be made more efficient just by the fact that the people come to one agency, and they get everything right from the outside of their premises, everything done in the same application. I think that's where it could, for businesses, really be a benefit. But I still feel that the parish system, I believe in the parish assembly system. I have seen people who have maybe a licensed premises going to open up next door to their house or underneath their flat. And I've seen the importance to people that they can put their questions forward they can get reassurance at a parish assembly from the licensee who is also in the same meeting, and they can walk away with something that meets both parties' needs by having that discussion, or otherwise it would end up to that they have to appeal once a decision's been made. And I think the parish is very good because we interview all licensed managers. If we get complaints in, and we do get a number of complaints, that we can contact the licensed manager immediately, have a really good conversation with them, and the matter is dealt with. It never goes back to the court as a problem because we have a very good rapport with both sets of people. And I think that's the bit that would be lost by not having the parish views.
Can I just ask from the other parish's point of view? So I think St Helier is sometimes considered a special case, not least because of the numbers of applications, but is that something that you could see other parishes doing? So rather, if there wasn't the licensing bench, is this something that St Bullard's, St Saviour could do in-house, or would you prefer the status quo?
Well, I prefer the status quo, but it's something we could do in-house. It wouldn't be a problem.
And would it be a problem if St Helier went a different, so St Helier did its own licensing, and then could that run parallel to a...
Well, I think it's important that the parishes, as 12, have the same policies. And in terms of the operational side, if it worked out that St Helier could do it for other parishes, fine. I think from St Bullard's point of view, because of the numbers we've got, we would probably, I think, wisely...
Still have your parish assemblies, of course, to consider.
Yeah, I think we've got
comments.
we've got sufficient administration to deal with it, which we do at the moment. So I wouldn't think there's too much difficulty in doing it.
But could it be, for example, I know we're speaking largely hypothetically now, could it be that the single point of contact might be you pop your application into the town hall, they process it, but if the application's in St Saviour, it comes to the assembly as usual, and then gets referred back to the town hall for final licensing approval. Appeal could still be with the court.
I think for me, it goes back to the gravitas of the situation against St Helier, but I think the fact the licensing bench issuing the licence at the moment, I think that's quite important, and that makes the licensees and the managers realise that actually it's quite an important role, and they need to act up to it.
Okay.
It does focus their attention. I mean, parishes are very good at the first stage because we filter out a lot of people who may not understand the system. So they come to us and we have a good chat. And most of ours are actually restaurants and corner shops with licensing. But we get people who want to start up as purveyors of fine wines and such like. And we did have one chap in said, yes, here's a map of my establishment. This is my storeroom here. This is where the secure lockup is. I said, no, that's not a storeroom. That's your bedroom. You need proper premises. This is totally unsuitable. And, we just make sure people format everything properly. So it's going to go to a licensing bench. Everything must be spot on. And especially with all your paperwork, if you're a sort of non-islander, obviously, you need all your papers in order, background checks for everybody. And the parish is very good at filtering everything down into a package so that once it's approved, hopefully, by the parish assembly, straight to the licensing bench, and it makes things simpler for them.
Okay, thank you. Any further questions?
Yeah.
Any points that you'd like to leave us with?
No, I think from the parish's point of view, we're keen to support the hospitality industry in reducing the red tape, as has been suggested, and we think that initially our proposal from the parishes was the simplest way forward, but as a consequence of other amendments, and particularly the time and running into the buffers with regarding to elections, I feel personally that Sir Philip Ballash's amendment is probably the one I would support at this point. What will happen in future years, who knows?
Thank you.
Ditto that, yes.
Yeah. Can I just thank you all for your time? Thank you, Comité. Thank you, Alison, for coming, and obviously to Connétables Crowcroft, who's had to leave early. We'll conclude this session now and ask for the tape to be switched off.
Thank you, Chair.